Right, so what I thought I'd do is I would look at, in three short videos, now that you know the general rule and the three general questions to ask about intoxication, I thought I'd break it down into three much shorter videos. The first one will look at voluntary intoxication, the second will look at involuntary intoxication, and the third one will look at intoxication and other defences. So it is true to say that if we're just looking at a dictionary definition, the idea of voluntary intoxication is where a person takes drink or drugs of their own free will. And free will is the critical point here. So they take drink or drugs of their own free will. And remember, as we've already looked at earlier, it can only be a defence for specific intent crimes. And the key thing to remember here, and it's something that I tell my students all of the time, is the ruling in Kingston. And we'll look at Kingston later, but the ruling in RV Kingston is that drunken intent is still an intent. And what that means, this intoxication is a defence of incapacity. It means that you cannot be liable because you are incapable of having liability. And the reason, as we know in that sense for intoxication, is that you cannot form the mens rea. If you cannot form the mens rea, then you can't be criminally liable. So therefore, if you can form intent, even if it's drunk, it is still an intent, so the defence will not be available. So whenever we're talking about intoxication, we have to be very clear that no matter what, the defendant has to have no mens rea. Otherwise, the defence is not available. And in RV Allen, although not specifically a case that deals with whether or not voluntary is a case for specific or otherwise, what it does is it does give us a very clear view of what voluntary intoxication means. And the defendant in Allen was charged with buggery and indecent assault, both of these being crimes of basic intent. He claimed he was so drunk that he had not known what he was doing. The reason for that was that he had drunk a certain amount of wine without realising how strong it was, and his intoxication should therefore be regarded as involuntary. In court, upholding his conviction that the Court of Appeal, upholding his earlier conviction, the Court of Appeal said that where a defendant knows he is taking alcohol, the drinking does not become involuntary just because he does not know its exact nature or strength. Intoxication remains voluntary even where the defendant claims he did not know the strength of the drink or the drugs. So Allen is guilty in this instance. He does not have the defence. Now, voluntary intoxication seems simple, but there's one area in which we have to be, or in which the court gives some special thought to, and that's the area around Dutch courage cases. And I'll just explain what Dutch courage means. Dutch courage is where you take what would normally be drink, but it could be drugs now. You take drink or drugs to give you the courage or the bravery to do something else that you would not normally do. And there's a reason why there's a fighter pilot in this poster, is that servicemen very frequently, certainly in days of old, used to take alcohol to give them courage to go into combat. If you remember, the Navy used to have the rum ration, and soldiers in the trenches used to get a tot of whiskey before they went over the top. And the idea for that is it would calm their nerves and it would help them to fight. Well, in terms of the law, the key decision for this is the Attorney General for Northern Ireland versus Gallagher in 1963. And in that case, a man, the defendant, had decided to kill his wife and drank a bottle of whiskey to give him the Dutch courage to do so. The legal principle that came from that is that the House of Lords, which reversed the original decision in the Court of Appeal, said that as long as the defendant had the mens rea of murder at the time of drinking the whiskey and did not positively discard that mens rea, he could be properly convicted. Lord Denning made it very clear. He said the defence is not available to either specific or basic intent crimes if drink or drugs is taken to fortify courage. If mens rea is formed before intoxication, as in Dutch courage, there will be no defence of intoxication. Here the intention to kill his wife was formed before he got drunk. So it's a matter again of when was the intent formed. So if you get a question on Dutch courage, you know that Dutch courage cases do not offer a defence. And finally, the last thing that I want to look at is the idea of construction. We've already looked at voluntary intoxication is a defence for specific, or can be a defence for specific intent crime. And we know this distinction between specific versus basic intent. Well, we may be able to reduce the sentence to create liability. And that's because some offences have a variation of specific and basic intent crime. If we take the Offences Against the Persons Act 1861 and we think about Section 18, which is a specific intent crime, GBH with intent, and then we look at its lesser offence of Section 20, which is GBH or wounding, which is a basic intent crime, we can, if the offence that we have charged offers a defence because it's a specific intent crime, we can charge with a lower crime because the mens rea will be fulfilled because it's basic. There are a number of cases or a number of offences where this is true. It is true of criminal damage. Criminal damage has specific and basic intent crimes in the same structure. GBH, as we've just seen above, and murder and manslaughter also have the ability to do this. Okay, now the key case for this is R.V. Lippman. And R.V. Lippman, 1969. And in R.V. Lippman, the defendant and his girlfriend each took a quantity of LSD, which is a hallucinatory drug. During his trip caused by the drug, the defendant imagined he was being attacked by snakes at the centre of the earth and that he had to defend himself. And in defending himself, he killed the victim, his girlfriend, by cramming 8 inches of bedsheet down her throat. The court acquitted him of murder because the jury was not sure that he had the necessary intention because he was intoxicated. But what they did is they convicted him of manslaughter. So they couldn't convict him, they didn't feel they could convict him of the specific intent crime, so they convicted him of the basic intent crime instead. So that's about as much as I'm going to look at in terms of voluntary intoxication. Our next video will look at involuntary intoxication.